This is Ryan Flax. I am the Managing Director of Litigation Consulting with A2L Consulting. And I'm joined today by Dr. Laurie Kuslansky. And what we're going to talk about today is storytelling and litigation, and why the concept of storytelling and the use of storytelling is so very, very important to winning a trial. I'll tell you a little bit more about Dr. Kuslansky in a moment, and she's going to explain the whole middle part of this presentation. And to give you a just brief introduction to myself, I'm a patent attorney, and I am a litigation consultant here with A2L. And I also want to let you know that at the very end of this presentation, there will be time for questions and answers. The audience, you can submit questions at any time during the presentation. I won't answer them live, but they will be logged in the question window, and we will get to them at the end. And I also want to let everybody know that following the presentation, you'll receive an email because this presentation is being recorded, and we will send you a link to use yourself or to share with others to rewatch the presentation. So let's begin. Well, the four things we're going to talk about today is I'm going to introduce storytelling and litigation, and then Dr. Kuslansky is going to discuss the psychology behind it and why it's so important, and then explain how to actually compose and tell a compelling story. And then lastly, we'll go into the visual component of storytelling. So first, let's introduce it. Well, litigation from the juror's point of view. So I can tell you with certainty that trying to understand the law and how the facts fit with it and consider both sides of a case is absolutely the most complicated and confusing thing that your jurors will ever probably do in their whole life. I'm going to give you one example from my background in patent litigation. So here is a rather famous claim from a rather famous patent. And I can explain why this non-English language here establishes that the defendant in my case infringes my client's patent. And I can do it from a patent attorney's perspective like this. This patent includes two key limitations. Number one, display an unlock image on the touch-sensitive display while the device is in the user interface lock state. And number two, transition the device to a user interface lock state if the detected contact corresponds to moving the unlock image along a predefined display path. So these are the key limitations because they're the only limitations disputed between the parties. Because the accused device includes these two claimed limitations and thus satisfies these limitations, and because the defendant does not contest that the accused product includes each and every other claim limitation, their product literally infringes the 849 patent's independent claim 19 pursuant to 35 U.S.C. section 271. Okay, so those are the facts, and I've explained how they fit in with the law and why the plaintiff should win, my client should win. But is that a convincing way to explain this to jurors? Absolutely not, no. So would it help you to understand the claim language, the circumstances, and why there's infringement if I told you and showed you the whole story? I suspect it will, so here goes. This patent that we're talking about, the 849 patent, belongs to Apple, who accuses the defendant, HTC, of infringing its patent, and specifically this claim 13. And here we're only concerned about whether the HT product, a smartphone, has these two claimed features that we've talked about. So what do they mean? Well, let's take a look at the iPhone to see, because it's the iPhone that this claim was written to protect. When developing its new smartphone products, Apple's engineers developed a novel and user-friendly way of unlocking the phone from its sleeping state, requiring the phone's user to swipe to unlock with a finger, and then allowing the phone to be unlocked only as a result of this intentional movement, and not accidentally unlocked in a pocket, for example, where your phone could do things that you don't want it to do. So this is a problem that was first encountered with smartphones because of their touch screens being exposed and very pressure sensitive. So seeing this iPhone, it's not hard to understand what the inventors meant when they used the language of touch sensitive display, because we can see the iPhone's touchscreen. We also see the unlock image there. It's a graphic on the touch screen where you can slide your finger like this along the unlock image to unlock the phone. And so now for the important part, where we keep you from pocket dialing your ex-girlfriend, we also see that the user has to swipe his finger in that way across that predefined display path there, and then only then does that user transition the device to its unlocked state. So we've seen how the phone works, and let me explain why it works this way. Now, Apple's inventors filed the application for this patent in December 2005, and that patent was granted, this patent we're dealing with here, in February of 2010, 5 years later. But the slide to unlock feature we just saw was included on the very first iPhone, and that was released to the public in the summer of 2007. Now, it's hard to believe that was just 7 years ago that the very first smartphone was released. I don't think anyone can deny that the iPhone design changed the way that the world thinks about mobile phones. No other phone was like it as of its release date, remember? If you can recall, back then we were all using flip phones and BlackBerries, which did not have touchscreens like this. And the very first Android phone, an HTC G1, didn't release until a year after the iPhone, and it didn't have this unlock with a swipe function. So, on the heels and in the wake of the unimaginable success of the iPhone products, what did HTC do? How did it design its latest mobile phones? Well, let's take a look. Wow, that HTC phone looks pretty similar. HTC, before the release of the iPhone, 2 years after that Apple patent was filed, didn't have a touchscreen phone. And now its phones unlock in exactly the same way as the iPhone always has. Interesting, huh? Okay, so there's my little story about infringement. And you can see it's a dramatic contrast to the dry and legalese way I explained it the first time. So this is a simple example about why using a story to explain your case at trial and using graphics to support your story are so important. If you don't remember anything else from today's course, remember this slide. This is my favorite visual that you'll see today. So imagine this poor college professor trying to engage his students and teach all that knowledge that he'd scrawled on the blackboard during a class. Or worse yet, imagine you're sitting in his class and expected to remember all this stuff that he's going to tell you. The point here is that you cannot just dump information on your jurors. You have to connect with them. You have to present that information in an effective way. So why is this so? Well, I've got just the person here with me to explain that. Dr. Laurie Kuslansky, PhD, is A2L's Managing Director of Jury Consulting, and she earned her PhD from Columbia University in psychology. Her dissertation focused actually on communication skills and audience comprehension. She's worked with every major law firm in the United States to improve and prepare their litigation teams for trial, and she's conducted over 400 mock trials in more than 1,000 litigation engagements over the past 20 years. Not 200 years, sorry, Laurie. And if anyone in the United States knows what it takes to persuade jurors, it's Dr. Kuslansky. So I'll step aside now and let her explain why, from a psychological perspective, it's essential to use storytelling when presenting your case at trial.
Thank you, Ryan. And it sometimes feels like 200 years, so that's okay. Welcome, everyone, and thank you for attending our webinar. You know, there is both art and science involved in persuading people, and many of you know the technical, factual, and legal basis for persuasion. What we'd like to add to that are both the science and the art of doing so that you can be more effective in that. First of all, we know, if we go to our next slide, that whether or not you provide a story, it's simply human nature for listeners to provide stories and connect information into a context. And so the question really isn't whether there will be a story, but in fact, the next point is whose story will be used. We know from doing mock trials and focus groups who are actual people who could in fact serve as jurors and may have in the past served as jurors, and find out how they react to fact patterns in case presentations. We consistently find that each camp of the mock jury, and in fact in post-trial interviews of actual jurors, that Each camp has a consistent story that it shares with other adherents of that group. That story tends to be short, it fits with common sense, it borrows some of the facts that stand out, it's complete for itself with a start, a middle, and an ending. It includes their version of what happened and what should happen. It only takes a few moments. It uses plain language, and once the group has embedded that story, it's difficult, if not impossible, to shift them off of that position. And so if we go to the next slide here, you'll see the answer that we want to go to is not only whose story will be used, but how do we go about that, and how do jurors make their decisions? We know that people automatically make stories out of virtually everything they hear. In fact, it's very hard to resist it. And we understand why that happens just using common sense, which is we want to have a sense of control over what happens around us and to us. And so we construct a sense of narrative in order to have a sense of control. That's how myths got created, and the Greek gods, and so on throughout history. And in today's courtroom, it's no different. If we take a look at how stories come about, you know, it's one way to just go through fact after fact in a timeline to tell your story, but a more compelling way will be, of course, to put it into a context of a narrative. And a great example of that is that you could go through the history of the Civil War, where, of course, there were different sides and different narratives for different participants, and you could go through the chronology from Fort Sumter straight through to the end, and it's unclear what you might remember or not, and how interesting some aspects of it would be or not. But there's a story that really stuck in my mind about it that I'd like to share with you, and in your mind see how that might stick going forward. There was a gentleman named Wilmer McLean. He was 47 years old, and he had retired from the military. He lived in Virginia, and sure enough, one day in July of 1861, he was in his kitchen where there was a fireplace, and a cannonball came out of the fireplace. And that is where the first battle of Bull Run occurred, because his home was actually headquarters to Brigadier General Beauregard. And Wilmer McLean decided that he really didn't want to be in the middle of all the chaos, and so he decided he'd move south. But unfortunately, a couple of years later, again, a messenger came knocking at his door and asked, "Can we use your home for the surrender of General Lee to General Ulysses S. Grant?" And reluctantly, Mr. McLean agreed. And the next day, the surrender took place, in fact, in Mr. McLean's parlor. He was alleged to have said that the Civil War began on his farm and ended in his parlor. It's a funny story and a serious example, though, of something that I suspect you will remember. And you may remember that better than the chronology of the Civil War by itself. As we move on, if we look at what the actual steps are that an individual on a jury would have to go through to convince other jurors and come to a decision, it actually involves quite a number of steps. And if we look at those steps in a flash, there are a number of them. They have to show up, they have to stay awake, they have to be motivated and pay attention, they have to be able to pay attention, they have to know what's important to pay attention to, because not everything is equally important. They have to understand what they're seeing and hearing. They have to be motivated and able to remember. Then they have to be able to remember, and it may be after some period of time, whether a day or a week or some months. Then they have to be able to repeat the information in their own words. They have to be willing and able to convince fellow jurors who disagree with them. And then the other jurors who are listening to them have to be able to repeat the cycle, which is during deliberations, if you go back up to the top of that slide, they have to show up to the deliberations, stay awake, etc. As we move on, we can see that there are a number of different sources of and basis for making decisions and processing information. One is the one that we've talked about largely, which is cognitive and somewhat physical, showing up, being awake. But it turns out there's also a social component that is less talked about and actually extremely important. And that will be, in part, the focus of our presentation today. What we've done is looked at some of the more recent literature and research in neuropsychology, radiology, psychology, and other realms that are relevant to discover what's new and what's surprising. And what we find is that there are a number of things that are surprising. For example, there's a researcher named Matt Lieberman, who's a doctorate in psychology at UCLA. He's the head of the neurocognitive laboratory that's doing very exciting research. And he found that when people are listening to stories and getting new information, that instead of what you would expect, which is that it would only activate the cognitive sort of centers of the brain, the prefrontal cortex, etc., that in fact it was other parts of the brain that were activated and that the information passed through a social network of information rather than by IQ centers of the brain. For example, it meant that people, in hearing the information, decided whether or not they would like to pass that information along to other people and which other people might find that useful and relevant. You would have expected, in fact, that brain centers that were activated involved the memory or deep encoding or higher level abstract reasoning or executive function and organization of information, but in fact that's not what happened. Instead, the areas of the brain, primarily two of them that were activated, had to do with thinking about other people's goals, feelings, and interests, which is called theory of mind. Those were the most highly activated parts of the brain. This leads us to the next question, which are, what are the implications of this? Well, we know that you can't change how jurors think in terms of their abilities or their capabilities, but you can change your approach to them. And you can put facts that you're presenting into the context of a story that is both verbal and visual. We're going to be talking about the highlights of what to pay attention to in doing that. We know from the current research that in order to spread ideas, norms, values, and culture does not depend so much on the IQ type of intelligence of people, but more on the influencers or litigators' social cognitive abilities, their use of emotions, and motivation. There's a whole host of data that will be in upcoming information that we provide that shows, for example, that in the Myers-Briggs inventory of personality, there's a really significant difference in the use of social information by litigators and non-litigators. So that's an area definitely that would merit paying more attention to, which is social cues and social information together with the literal, verbal, and legal information. We know that by providing relationships between facts and characters and addressing their motives or intentions and putting the information into a context, you will definitely be more persuasive because those are the things that seem to matter. And how do we know this? Well, there's been hardcore research by researchers in radiology as well as psychology that have looked at the brains of speakers and listeners listening to stories. And it turns out that those brain scans or functional MRIs sync up. If we look at the next slide, we can see an example of this. On the top we have speakers, on the bottom we have listeners, and it turns out that if you look at the first panel on the left, the top being the speaker and the bottom being the listener, that you have a matchup of that yellow spot that shows that there is an activation in the same part of the brain of the speaker and the same part of the brain of the listener. Other interesting findings that we see here are that sometimes they happen at the same time, which is the yellow. Sometimes it happens
Hi, Laurie. I think we lost you for a second there, but I know what you were saying is that sometimes the listener can even precede the speaker in one of these situations because they anticipate the story that's coming.
That is correct. And what's amazing, can you hear me okay?
Yep, we can hear
Brian,
you now.
can you hear me?
I can hear you.
Fantastic. Okay, well then we're coupling, as they say, or neural coupling. And so what's really fascinating of this research is that not only is there a matching of the timing and the types of activation of the brain, but also where is that happening. And where it's happening, again, like the research that we just found from Matt Lieberman, is in the areas to do with understanding inferences, storytelling, and other people, theory of mind information. So there's a significant overlap between those two areas, which is not what you would expect. And what that means in part is that your brain of the listener is simulating what is being told in the speaker's story. We also know that if we go to the next slide, other things that the brain has done in relation to stories. Now, the elements, of course, of stories have to do with the words. We find, in fact, that research shows from brain scans that the brain reacts differently based on the types of words that are used. Not all words are created equally. In specific, when you're only using factual words without any adjectives or sensory information, the brain only processes it in two main areas, which is Wernicke's and Broca's area of the frontal cortex, the language areas that are just relating to the words as such, and it comes out as blah, 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 blah. In fact, the listener will only be able to remember the words as such, and so it's quite a significant memory task to remember all the words, know which ones are important, etc. However, as we move forward, it turns out that stories that incorporate metaphors and sensory experience activate the whole brain, not just those areas that have to do with words. Specifically, it was found that when you include language that has to do with specific sensory information such as scent, lavender, cinnamon, things that are very potent, that the olfactory cortex get activated in the listener's brain as well as the speaker. When you talk vividly about movement, racing like a racehorse, that actually the motor cortex of the listener also gets activated listening to that. And so what we know is that you can activate more of your listener's brain by activating it with more descriptive language having to do with metaphors that are not hackneyed, but that actually move the listener to have their brain wake up and move with you. We also know from our next slide that effective stories can actually change our brain chemistry, which I think is rather shocking. Research was done by someone named Paul Zak, who is a neuroeconomist, and he was interested in whether people listening to certain information would have sympathetic or empathetic reactions, and if that would in fact relate to how they responded to it, both in terms of their behavior but also in terms of brain chemistry. What was found after telling these young men stories about needy young people, and the amount of oxytocin in the brain was measured both before and after because it's an indicator of empathy, that in fact, after listening to the stories that elicited sympathy, there was an increase in oxytocin, and in fact a relationship between the amount of oxytocin that was found and the degree of donation by the listeners to the so-called needy recipients. We also know that hearing inspirational stories has caused more blood to flow to our brainstem. And the brainstem, many of you may know, but this is based on a study by Mary Helen Immordino Yang, who is a neuroscientist and a human development psychologist. And she found that this part of our brain, which makes our heart beat and regulates our breathing and keeps us alive, can actually literally make you feel inspiration on the very substrate of your own biological survival. So that's rather compelling information that inspirational stories move blood flow into our life source. So far we know that brains use the same networks to process stories in other people, that more of the brain goes to work when more than just plain words are used, that new information passes through a social filter, that our brain chemistry is changed by the use of certain language, and that our default mode is to string information together to form a narrative. But what else do we know about stories? Research has shown that stories actually interrupt daydreaming. A researcher who's a psychologist named Jeremy Sue has written a book called The Secrets of Storytelling, Why We Love a Good Yarn. It was published in Scientific American in 2008 and goes into more detail about these findings. In addition, we know that stories organize information and that, in fact, our brains are wired to enjoy stories. This leads us to our next segment, which is, all right, I think that we all understand how important it is to tell a story, and frankly, probably some of you are out there already assembling some sort of narrative about the webinar, and so you understand how automatic it is to form some sort of impression, and that impression becomes a story. In fact, 65% of the time of what we're talking about is either a story or gossip, and obviously that proportion may differ by individuals. But in order to tell a compelling story, we've looked at a couple of different sources. Now, of course, any of you can go to a comparative literature or English literature course or writing course as part of your training, and that's certainly a good idea. But there are other sources you can also go to. And what we've done is try to assemble some of the best information from different sources that we think will be helpful to anyone interested in compelling story making. For example, Jonathan Gottschall is an author of a book called The Storytelling Animal, How Stories Make Us Human, and a co-creator of The Science of Storytelling, How Narrative Cuts Through Distraction Like Nothing Else. And his research has shown that in order to impact us, a story has to do three things that we can see on the next slide. One, it has to emotionally transport us. In other words, we must be moved by it and sort of get lost in it. You know, there's a lot of stories that fall kind of flat. There's ways to tell stories to make sure that they do fall flat, but there are other ways to transport us and move us. Well, how do you do that? We go to the next point, which is you have to include humans facing problems and overcoming those problems. But those problems can't be meaningless problems or ones that have only meaning to you or your client. They have to be more universal. And therefore, your message has to communicate some sort of message or moral, just as it did in mythology. And it has to include some set of values or ideas, or it will seem empty. As we move on, how can you make your case into a story? You know, you may be dealing with a dry list of patent numbers or a bunch of insurance or reinsurance documents or a group of contracts that don't have a whole lot of spice to them, and say, well, where's there a story here? There's no story. There's just a chronology of what happened. However, what we have always found is that those documents didn't produce themselves. Those inventions didn't invent themselves. But in fact, people at some point were involved in the creation of those events. And if there are people involved, and there are people that will be impacted by what happens in the case, then you have a potential story. The first thing you need to look at is what's called themes of your case, which I'm sure many of you have heard about. But we'd like to talk a moment more about the science, not just the art of themes, because the impact of themes is something that we call in psychology priming. An example of priming is research that was done that showed half of the group of subjects were told a group of adjectives that were negative, such as obstinate, aloof, stubborn. The other half were given adjectives that were positive, persistent, inquisitive, independent. These were not given in any context except a list of words. Both groups were then presented with information about a fictitious individual named Don. Don engaged in various activities and certain behavior. The groups were then asked to rate Don in terms of adjectives, positive or negative. And consistently and statistically significantly, the group that had been primed with the negative words consistently rated Don more negatively as being obstinate and aloof, and not in a positive way as the group that had been primed with those positive adjectives prior, who rated him as being independent and persistent. And remember, they were both presented with the same behavior and the same conduct. And so you can see that in such a very short amount of time, these people were primed, and it had such an incredibly powerful impact. The reason that's relevant to you as litigators and persuaders is that you can prime your audience with just a few words to know what to expect and how to frame the information that they're about to hear. You also want to make sure that you include compelling characters, whether good or bad. Who are the heroes and the villains? Because those are the stereotypes in our mind and the hierarchies that we fit things into automatically. We also, even if the law doesn't require it, human nature does require answering the motive of the behavior that people have undertaken. Why did they do what they did, or why didn't they do what they didn't do? In every good story, there must be an arc. There must be a conflict, and there must be a resolution. Very often, for example, in patents, we think about just the science of what happened and the prior art. But what humans want to hear in terms of a story are some of those stereotypical in the garage inventions and the problems that were solved by those inventors that created a solution in that patent, and that they were first. Those are the things that matter, as opposed to some of the more technical information. Jurors also, in a good story, want to hear the messages, what the consequences are, what will happen with their decisions as a result. Will somebody win or lose other than the people that are litigants? Will the community benefit or suffer? And will there be policy changes that are good or bad for them? Now, in order to figure out some of these elements, the first and foremost question to answer is a simple one, and in fact, not the one that we typically hear people asking in litigation. And that question is, what really happened here? Not what happened legally, not what happened chronologically, what really happened here. So, for example, what really happened may be that one partner was having a midlife crisis and decided to invest in a new car instead of the business. Or what really happened is that one partner became jealous of the other partner, etc. Those are the kinds of things that really happened that motivate human behavior to change or to stay the same. And those are the things that are very powerful, whether it's in something as serious as litigation or something as universal as comedy, that what's true and universally true is the most powerful, compelling, and persuading. We also find, unfortunately, that many people in litigation do not ask this question, or they answer it by rattling off a series of events, but not the bottom line. There are other questions that also are important to go through in terms of figuring out the human story of how you can tell a real story. Why did they do it? What were they thinking and feeling? What did they know or not know? We know that knowledge and control are the two biggest parameters of decision making. And so finding out who knew what when and what did they do or not do are probably amongst the two most important things that you can ask in terms of deciding how to tell your story. As we continue on our next slide, there are other sources that are really great to understand how to tell a good story. We know that Frozen just won the Golden Globe Award because it was such a great animated version of a story. I don't know how great a story it was without the animation, but it certainly helped. We know that from Pixar, who's certainly had success in telling and showing stories, that there are lessons to be learned. Another persuasion professional named Dr. Ken Brodebaum has looked at the success of Pixar and its storytelling and the elements that have led to its success in terms of how it tells a good story. For those of you who like their stories, and we certainly respect those of you who don't. But in that study, we decided to further be leaner and meaner and really cull down the most important aspects of how to tell a compelling story from that resource. One is, what is the essence of your story? In other words, what's the most economical way to tell your story? You may have to skip over things and skip over your detours and stop digressing to tell more information, but it'll pay you back, because even though you feel like you're losing valuable things, it'll actually set you free, because it will be less distracting to people who are trying to figure out what's most important. And so you have to be able to really take out anything extraneous, number one. For example, there are extra words that are not necessary, such as forcible rape. Rape is already a forcible act. So you want to be sure that you're not using words that you don't have to be. In addition, you have to decide, why must you tell this story? What is that burning desire that that story has to be told? And what is the heart of it that really drives it? Why are the parties litigating? Is it just money? Because that's not enough to move most other people other than the ones who are there to either win or lose that money. Or is there a principle at stake that more people can in fact relate to? If there is a principle, hopefully there is, then you have to make sure that you're conveying that principle and show that it is a burning belief and build your story around it in order to transport or move your audience. Next, what are the stakes? Why should jurors root for anybody, either for a good guy or against a villain? And what happens if that good guy succeeds or the villain succeeds? What are those stakes? Very often, people think of it in terms of very narrow terms, which is if you decide X, then the result will be Y, certain amount of money, etc. Again, that's not a compelling story. Those are stakes only for the stakeholders in the case, but you need to understand what are the stakes for the outside triers of fact who are also stakeholders in the community. In addition, you need to tap into what sort of universal morality you can. Such things as loyalty, fairness, balance. And if you can find that, can you provide it to jurors so that they have something more to drive their decisions and their commitment to your side or against the other side than merely a cognitive task of making a decision based on a list of facts. Next, you want to make sure that what you're doing is interesting for your audience and not just for you. When you say this is really interesting, think about what that means. Is that interesting for the outsider or it's just fun for you? For example, I can speak 4 or 5 languages, but that wouldn't be that interesting if you didn't speak those languages and I started to speak them. I'm not here to show off my vocabulary. And very often in presentations in court, we see people speak to the jury in language that no one in the jury will understand, whether it's words such as notwithstanding and things of that nature, which are simply jargon that regular people on the street don't use. So that makes it not interesting. In fact, it puts up a wall. You want to make sure that what you're doing is not just fun for you as the writer, but that it's fun for the audience, that it's interesting and keeps their attention. As they say, be a guide by their side, not a sage on the stage, sort of a tongue twister. In addition, you want to make sure that you've identified who the key characters are and make sure the people in the decision seat can identify with them or against them so that jurors would ask themselves, well, why would I act that way or why would I not act that way? What's interesting here is that you may be making assumptions about how jurors who are like the key characters would identify with them. We sometimes find that. We also sometimes find, and you can only learn this through research, that they do the exact opposite. In other words, let's say that someone is a daredevil on the jury and the plaintiff was a daredevil. You might think, well, that's risky because the daredevil on the jury, if you're a defendant, will identify with the one who was the plaintiff. It turns out that very often something called defensive attribution happens where the person like that plaintiff will say, well, I wouldn't be so stupid and let something like that happen to me, and in fact distance themselves. So really look carefully at key characters and whether or not you think that people will identify with them or reject them. And then, it may seem obvious, but it isn't always. Make sure that you are clear that you've come up with your ending before you have figured out the start and the middle. And the reason is that your ending is like GPS. You won't know how to get there unless you know your destination first. And that will help you in determining the stepping stones of your beginning and your middle so that it's coherent. In addition, we've learned other things about stories and what people remember and what they are persuaded by. One, that the simpler the story, the better. The better it's remembered, the easier it is to relate to, and so forth. I'm sure that everyone who's heard it understands Mr. McLean's frustration when he tried to get away from the Civil War, and just like a good story, it followed him. He could run, but he couldn't hide from it. We also know the simpler the language, the better. So it's not a place to show off vocabulary. It's a good place to use the same language as the ordinary person on the jury. We know that using metaphors involving sensory descriptions will be much more compelling. People in some of the less cultural arts, such as soap operas, are really good at that. and whatever you may think about them otherwise, they're good at using good metaphors and rich language. Reduce the facts to a relatable story, and then use word pictures. What are word pictures? I'll give you an example. A word picture enables the listener not only to hear the words, but to also simulate or conjure the experiences in their visual mind. So, for example, compare the difference of asking and answering the question one way that I'll show you versus another. For example, question, why did that email in particular stand out to you? Now compare the simple non-word picture answer, because the subject was in caps, to the word picture answer, because when that email came in, it was very early in the morning. I was groggy, and I was drinking my second cup of black coffee. And while I was drinking my coffee, I was pressing the down arrow to scroll through my new emails, and there were lots of them. That email stood out when I was scrolling because the subject was the only one all in caps and bold letters, so it caught my attention. As stated in the New York Times, narratives offer a unique opportunity to engage our capacity to map other people's intentions because stories enable us to identify with characters, their needs and frustrations, to guess at their hidden motives, to track their encounters with friends and enemies, to judge their choices and their outcomes. We often discuss cases with attorneys who know the facts and the law, but who do not consider the simple story. They actually resist it in favor of listing facts. And we understand that there are compelling audiences and reasons to do that, whether the judge or the record, or a potential appeal. But we also know that a good story can help all of them. Remember, mediators and judges are also human beings, and their brains don't operate differently than the rest of us, although without names, some of them might. So if you succeed at telling your story well, the jury's brains will literally be on the same wavelength as yours. With that, I'd like to pass the floor to Ryan, and I thank you for your attention.
Hi, everybody. I'm back. Well, I just want to thank Laurie for that super interesting part of the presentation. I mean, I've, of course, heard these things from her before, but I love hearing it every time because I really, really like having the scientific foundation for all the principles that I believe in my own practice. And so what I want to move on to is a little bit more science. And what we're going to talk about now is the visual component of storytelling. Right? Because who are we telling stories to? Well, human beings. And humans have eyes. In fact, our eyes are pretty important to us. And I think we'll all agree on that. And if that's so, does it make sense to tell a story with only your voice? Would you rather listen to a news report on the radio? Or would you rather watch that same news report and story on the TV? And which way do you think tends to sink in faster and more completely to your own brain? I know for my own, I would prefer to watch it on the TV because I can get the information almost instantaneously compared with making an effort to try to absorb it. So let's talk about some of the science here. Well, society in litigation is divided into two groups. Normal people, and I put that in quotes, and attorneys, right? Non-normal people, as we might be. So studies show that the vast majority of what we're calling normal people prefer to learn visually. That's about 61% or more, depending on the research that you look at, of the general public prefers to learn by seeing something. The majority of attorneys, on the other hand, do not prefer to learn this way. 53% of us prefer auditory and kinesthetic learning, which means that we prefer to learn either by hearing or by experiencing something. And I think this makes a lot of sense when you think about it because we as attorneys all learn this way in law school by sitting through class lectures. And then we all continue to learn this way as practicing attorneys by experiencing litigation because no one sits down and teaches you how to do anything for litigation. But most people in the outside world do most of their quote-unquote learning by watching TV or surfing the internet. And my theory on this is that these learning preferences of normal people are solidly based in evolution. This is not something that I've seen tested, so I guess it's really just my hypothesis here. So if there are any behavioral anthropologists in the audience, please take up this cause and let me know. But I believe that humans evolved from animals that had to rely on learning visually, because socially and anatomically, there's a lot more to see and learn and less ability to orally explain things to one another. Our ancestors saw what fruit to collect and eat. They saw their neighbors catch a fish. They saw their father hide from a carnivore, and they learned how to live, and this learning style was thus evolutionarily reinforced. And I think that unless a human being is forced into a situation, i.e. law school, where he or she must hone their ability to learn by hearing a lecture, they'll more easily learn by seeing something and relying on their much, much stronger visual capabilities. So now that we know how people prefer to learn, how do people prefer to teach? Well, no matter how smart you are, you typically teach the same way that you learn unless you carefully plan to do otherwise. So if you're a visual learner and you learn by seeing, you'll typically teach by showing. If you're an auditory learner like we are, you typically teach by giving a lecture, unless you take great efforts to do otherwise. So, what's the problem with that in a courtroom? Well, there's a tremendous communications gap, because most of your jurors don't prefer to learn by being lectured to. And if you teach them and argue to them in the way that will feel most comfortable to you by giving that lecture, you're not being as persuasive as you could and should be. Your jurors simply won't get your points for your case as well as they should. So how do you bridge this communication gap? You have to plan to bridge that gap with demonstrative evidence, with visuals to support your stories. Because with effective demonstratives, you can teach and argue, tell that story from your comfort zone by giving that lecture. But your visuals, your graphics, your other demonstratives will provide your jurors what they really need to understand what you're saying and give them a chance to agree with you. Jurors that understand you, but to be fair, they probably will never really understand what you're saying or why you should win. But if they feel like they understand you, then they're more likely to agree with you, because they'll feel that their opinions, which are now based purely in emotions, are founded in reason and logic from your argument. The graphics will also allow you to impact your jurors on an emotional level, and we know from the storytelling how important that is. So these two gentlemen, Dr. Park and Mr. Fannington, these are right now two of my favorite people in the world, because last winter, Dr. Park, who's a psychologist, PhD, and a professor, and his partner, an attorney and a law school professor, Dr. Fannington, they published the results of their work researching attorney persuasiveness with and without supporting graphics. And their results, as reported, are astounding and, to me, tremendously validating. So what did they find? And what did they do? Well, using two different studies, each of those two studies having 4 groups of jurors, the researchers tested persuasiveness and impact of opening statements in an employment discrimination case, a simple type of case. So one group of jurors from each study saw no graphics at all during opening statements. One group saw graphics with the plaintiff's opening, another saw graphics with the defendant's opening, and one saw graphics from each opening. And this was, as I said, done twice, so a total of 8 groups. And what were the results? Well, they found that PowerPoint enhanced persuasion both through the central and the peripheral processing of the jurors. What does this mean? Well, what this means is that when you force jurors to think about something and they have to use their central processing or their slower brain functions, you're persuading them with visuals. And when you don't force them to think and you're instead having them react to your arguments and using their fast thinking, their peripheral processing, you're also enhancing your persuasion by using and what were pretty rudimentary graphics. So in turn, this increased each party's persuasiveness during opening statements. And what does that really mean? Well, When the plaintiff used visuals, used demonstratives with opening, the defendant was more liable or more responsible. And the flip side of that was when the defendant used them and the plaintiff didn't, the defendant was less responsible. So imagine you're using graphics and the other side isn't. But imagine worse than that, if you're not using graphics and the other side is, you've got yourself in quite a deep hole. So why is it persuasive? And how did the jury react to the visual component of the presentation? Well, the jurors felt that the attorneys using visuals were more persuasive because they felt that they were more competent and more credible. And again, these are scientifically valid results. Now, more likable, I have a question mark next to because the researchers were not terribly clear that that was a scientifically specific result, but they believed that was the case. The jurors retained the information better, and the result was the better verdicts that I mentioned before. So what's the take home from this study? Well, it's that demonstrative visual graphics are essential and mandatory component of any litigation. And if you're not using them and your opponent counsel is, you are in a heap of trouble. So now that you know that you must use a visual component to your storytelling, to your opening statements, to your closing argument, throughout your trial, the next question is, well, how do I do it? Well, Dr. Ken Bertabaum, who Dr. Kuslansky mentioned earlier, he did another study with actual mock jurors, and he tested exactly this. What style of presentation with visuals makes a difference? So Dr. Bertabaum tested a presentation, oral argument, with no graphics at all, one with the old style flip chart graphics that if you can remember from the old days of trial where people are actually writing on paper, professionally made graphics that were static and also sporadically shown, which means once in a while. Fancier animated style graphics, also professionally made, but still shown sporadically, meaning only once in a while. And so what Dr. Bertabaum found was that those first four styles of presentation actually didn't have much difference in persuasiveness, which to me is quite surprising because I would have thought initially that use of any graphics at all would be better than none. But what he found was that really the immersive technique was the only one that really upped the game. And so what did he find? Is that in the immersive technique, meaning that you always give your audience something to lay their eyes on while you're speaking, the jurors were more prepared on the information. They thought the information was more important. They paid more attention, they comprehended better, and they retained the information longer. So as I said, the research shows that only the immersive style makes a difference. Now, this doesn't mean that every single thing that you have during your presentation needs to be an extremely fancy, expensive graphic, but it needs to be something to lay your eyes on. For example, the agenda slides that we've shown you during this presentation today. So what does all this mean? Well, I believe that you need to address litigation with a two-track litigation plan, track 1 and track 2. Track 1 is develop an effective presentation. Track 2 is develop that comprehensive record. And as attorneys, really we only learn track 2 in law school. We learn what's the law, how do the facts need to fit into it, what's my prima facie case. Really this means what does the appellate court care about? What do I need to prove to win? But I can tell you who doesn't care about that stuff. It's probably your jury. What your jury wants is the story that Dr. Kuslansky talked about earlier. So you need to think about your effective presentation as early on in the case and plan for it as early on in the case as possible, which means if you're the plaintiff, before you file that complaint. If you're the defendant, as soon as you get that complaint served on you. Of course, thinking about your presentation and planning for it is something that's going to evolve over the course of the case, but you need to plan for it early on. And I find that most litigation teams don't do this. They don't start thinking about their presentation until maybe a couple months before trial or even closer to trial, and they lose because of it. So when you're designing your graphics, there are 4 main keys or rules of thumb to information design. The first one is simplify the complex. Well, this is something we've talked about before. It's a basic of storytelling, and you want to create instructive, easy to graph, supporting graphics that will memorably and quickly and effortlessly convey the complex information of your story. Number 2 is exploit the iconic. There's lots of cultural templates out there in the pop culture that we all understand instantly. A stop sign, an exclamation point, the question marks you saw earlier. These are all things that convey information almost instantly, and you engage only your audience's fast-thinking brain because they'll react to it without having to think about it. These are things that you want to exploit during your visual support of your presentation so that you don't force your audience to think too hard. They feel your story. Third is emulate generic fictions to produce the truth. Now that's a mouthful, right? But what this basically means is that the key to storytelling and the key to your supporting graphics is to adhere to this, because social psychology studies show that different sources of information aren't neatly separated in jurors' minds, and that this fact can be exploited in your visuals and your storytelling. Because your visual meaning is malleable, you can design your visuals to show the generic fiction that you want your facts of the case to fit. For example, there was a reasonable cause for the defendant's behavior, or the plaintiff had all the information he needed to enter into that contract. The essential generic fiction in any litigation and for every jury is that of cause and effect. People, jurors, are intensely hungry for cause and effect to give a sense of logic and reason for what otherwise are only their emotional beliefs. This is where storytelling comes into play, and this is why it's a key to information design. So one example of this rule of thumb can be found in the trial against the LA police officers in the Rodney King beating case. To win that case, the prosecution was relying on the home video footage of the beating taken at the scene, which we all saw as consumers of mass media, and I think we can all agree it looked extremely violent when played from beginning to end. The defense in the case took that very same footage, slowed it down to a frame-by-frame progression, and their expert told a story about how each baton hit by the police officers was actually a reaction to an aggressive movement by Rodney King. A perception of causation was induced in the jurors, and they adopted that perception as the truth. So whether they were right or not, the defense won. And many attribute their victory to racism on the part of the jury. But actually, it's attributable to the clever use of demonstrative evidence in this way. So here's another question. When has this technique been used recently? And I'll give you a hint. It's in a very well-publicized patent infringement case. The answer is in the Apple v. Samsung trial last year in the Northern District of California. And Apple, during the trial, used this smoking gun email from Samsung executives. And I'll put smoking gun in quotes because that's their story. Samsung executives were praising the look and the design of the new iPhone, and Apple's attorneys induced in their jurors the perception that this praise and recognition for quality design led to Samsung's intentional copying of that design. Apple attorneys also went on to show the jurors this graphic. Jurors want a story, not a legal case, and this shows that and makes that example as an example very well, because when asked to point to the evidence that compelled their verdict, juror Manuel Yagan explained, on the last day, Apple showed the pictures of the phones that Samsung made before the iPhone came out and ones that they made after the iPhone came out. And this visual evidence that you're seeing in front of you was enough. This tells the story, right? Along with that smoking gun email. Before, then the iPhone design, and then after. So this juror went on to say, we were debating about the prior art, and the prior art means the stuff that came before the patent that could invalidate it. And he goes on to say, Hogan was jury foreman. He had experience. He owned patents himself. So he took us through his experience, told a story, right? After that, it was easier. Jurors brought their own story, as we heard before. He goes on to say, after we debated that first patent, what was prior art? Because we had a hard time believing there was no prior art. In fact, we skipped that one so we could go on faster. It was bogging us down. So what are we learning here? we're learning that the jury just skipped talking about difficult evidence. Instead, they relied on how they felt about the case, on the story that was weaved by the plaintiff's counsel, and as we discussed, they relied heavily on the background and experience of other jurors and on their stories. And the result of this case was $1 billion and plus in damages for Apple. But what does this really tell you? It says that while you need to be very concerned about how your facts and the law work in your favor, to win at trial, you need to hit those jurors where it counts in their emotions. The final rule of thumb is to respect the medium. Your jurors are going to expect a visual presentation. They're going to expect stories, because where do they get their impression of what happens at trial? They get it from TV and the movies, right? So they want a multimedia presentation with visuals, with sound, with video, with document evidence, electronically shown to accompany your story. So the bottom line is making the simple complicated is commonplace. Making the complicated simple, that's creativity. So the bottom line is each graphic needs to relate one idea, right? One part of your story. So finally, I just want to show you a bunch of opportunities to use storytelling and to use supporting visuals. You know to use graphics at trial. Testing. You know you need to use graphics during mock exercises. Expert reports often require graphics and often need a story to go along with them. One you might not think about is mediation, because you're only going to have a few hours to convince a mediator that your side needs to win. You need to be as persuasive as possible during that, and the way to do that is to tell a story and support it visually. Then again, at settlement conferences, if you have a compelling story there, you have awesome supporting visuals, and you impress your opposing counsel, they'll have to take you more seriously. And finally, in depositions, an effective time there is to either set the stage for trial and create the reality you want with visuals during depositions, create the story you want, or if you have witnesses that are likely not to show up at trial or beyond subpoena, make graphics to use a deposition that you can later use as exhibits at trial. So now we're at the question stage of the case, and we're sort of at the end of our story in our webinar. And so I hope what we've said today has given you a lot to think about and a new way to approach your next trial. So if anyone has a question for Dr. Kuslansky or myself, you can ask it now with the chat function or the question function of the GoToWebinar software, and we'll do our best to answer it. Let's see, what do we have here? First question is, how do you introduce your story in jury selection with limited ability to get into the facts of your case? Well, that's a great question for Dr. Kuslansky, who helps with voir dire constantly. Dr. Kuslansky?
Sure, thank you. That's called indoctrinating, and it's a very advanced skill. Let's remember that the main objective of jury selection is actually deselection, which is to get rid of people that will reject your story, which is a little different than telling your story. So what I would recommend is take a summary, one paragraph of your story, and what a compelling point is. So for example, let's say that your case involves expert testimony from a psychologist. What you want to do is incorporate that into what would be rejected. You might say, for example, that our case is going to rely in part on expert testimony that's very reliable from a psychologist. Some people think that psychology is very useful. Some people think that it's voodoo. Which one would you say you are? So that you want to make sure that you've posed it in a way that when you introduce the subject, you're also eliminating people that will reject it.
Okay, so our next question, and this question I love, it reminds me of A Few Good Men, and I'm going to try to read it that way, is that in a trial, among other things, we want to find out the truth, right? That's my Tom Cruise impression. Aren't stories detrimental to the goal of truth? How do we ensure that jurors are in a position to check whether stories are true or false?
Okay, well, that's a great question. I asked that many years ago, and I was told by a very well-known attorney whose name will go unnamed, nobody wants the truth in litigation, you just want to win. That's sort of a pragmatic answer to what litigators are there for. Although the prosecution in a criminal case may be really, in fact, in search for the truth, what my understanding is that people want the truth to work for them. The story doesn't necessarily get in the way of the truth because everyone's going to tell their version as they see the facts of the truth. I published an article many years ago called Justice or Just Us that goes further into it that I'm happy to supply if anyone is interested. But the story should not be a fabrication. The story should rely on actual facts, on actual testimony, and should be a succinct weaving together of the pertinent highlights that fit along with the agenda of that litigator.
And one thing I'll add is that the truth is found in the evidence, and the evidence is going to be presented at trial. You're going to show it to the jurors, and if that evidence fits in with the story that you've excellently told during the trial, then that's the truth. The appellate court will sort it out later, and they'll tell you whether your truth or their truth is the right truth. But that's really how it goes. So the next question is, what psychological dynamics present in the minds of attorneys who do not appreciate the value of telling interesting and thoughtful stories supported by intelligent and informative graphics? That's a tough question, but do you have an answer to that, Laurie?
Yeah, I have the beginning of it, and you may have the end. The psychological dynamics of attorneys might very well vary. It's very individualized. But I think that any presenter who doesn't appreciate the audience, needs the level of information that they have or need, and the form of information that they will need to be taught and persuaded, is being somewhat narcissistic or egocentric or simply naive in not understanding and appreciating what the informational needs are of the audience. So that would be part of the psychological dynamic. If you're going further into that, there is Myers-Briggs information that shows some more specific traits that are generalized based on groups of people that may or may not apply to an individual.
Well, what I'll add is this. When you're confronted with the truth that jurors want a story, some attorneys react to that with frustration, potentially a little bit of fear, because we are so fact-driven and specifics-driven. And I'll give you one example from my last trial. It was a patent case, patent infringement trial, that I had personally worked on for 5 or 6 years before we got to trial. And as we approached, after I had done all that 6 years of work, considered every single contingency that could happen, every argument that could be laid against us, and what our best responses were, and how we were going to win the case, both factually and scientifically, the partner in charge of the case came and said, and this was on the eve of trial, well, the science doesn't mean, and I'll leave out the whole word, but S, right? Everyone gets what I'm saying. Science doesn't mean S. Now, as a scientist and a patent attorney, and somebody who just spent 6 years caring intensely about how the science mattered, to me, it was almost offensive to hear that. But what I know is that he was right, because the jury could really care less about the specifics of the science or the facts of your case. What they want is a compelling story, and that's why we won, because we had a compelling story. Now, all the facts fit in with it well, which was the truth to answer the last question. But it is factual that clients don't care about facts, or that jurors don't care about facts. So the next question is, what is the dividing line between immersion and overload? Well, that's an interesting question. I'll address that. I don't know that you can overload a jury with visuals unless you are throwing visuals up that don't support what you're also discussing. That would be probably the line for me. You don't make a graphic for a graphic's sake, usually. It must fit with everything else. The case is not driven by visuals. Visuals are there to support the stories that are being presented by the litigators. So overload is not following that rule. Let's see, next question is, should you use visuals on cross-exam, particularly when impeaching with a transcript? Well, the answer to that is yes. The first visual for that is the actual transcript. That would most likely not be something that was made by a graphic artist, it can usually be easily pulled up by your trial technician using either sanction or trial director, and either pulled up in text or pulled up in video, even better, of a prior inconsistent statement, for example, to impeach that witness. But on some occasions, maybe you've developed a graphic that really impeaches a witness or something that you really want them to explain or talk about. And in that case, definitely have something built, locked and loaded to pull up at trial, either as an electronic display or as a board to go over with that cross-examining witness.
Yes, and I'd like to add a drop to that, which is that the research has shown from actual juror debriefings after trials and verdicts that what happens when you have those moments, which are very rare in terms of, Perry Masons, for those old enough to remember that, that's not usually what happens. So in other words, it's not so clear to jurors that you have an aha moment in a cross-examination for the jury as it is for the attorney involved. And what the research has shown in addition to that is that having a visual that really makes it pop makes a point of common reference for the different camps on the jury. So people who are with you as well as people who are against you at that point will have that common point of reference that helps bring them together in terms of discussing the impact of it later on in deliberations. And that in and of itself helps towards consensus.
All right, so the next question is, are there any studies done concerning the jury's prejudice against a large corporate defendant using expensive graphics at trial when there is an individual plaintiff?
Yeah, there is actually. There is a variety of sources on that, but what's very interesting about it, it's been done nationally and repeatedly, is that especially nowadays, most jurors who have children who are 8 years or older already have what appears to be the same technology at home, and they're doing book reports that are on PowerPoint that don't look very much different from a lot of the presentations in the courtroom. They also believe that the courtroom is, and very often it's true, already wired for sound and visual, and that a lot of the equipment that is there belongs to the court. So oftentimes they don't understand why one side would use it and the other side wouldn't, because they don't understand that there is a differential potentially in the cost for using it. Thirdly, it isn't as if the kind of technology that's being used is showing up as a hologram. What we're talking about are visual, audio, animation, photograph, etc., very sort of basic types of visual arts. So there's nothing that unusual in terms of how the output looks. In addition to that, the research has shown, even in places that are somewhat rural, where you might think that jurors will hold it against the large corporation that they're being glitzy, that it's really fewer than 5% of the audience that may think that, and that the majority, 95 to 97%, simply thinks that that good presentation simply is a good presentation by a more organized presenter who cares more about keeping your attention, making their points clearly, and that they're more believable and persuasive. So the odds are all in your favor to use good presentations visually as opposed to worrying about the downside of appearing big and glitzy. Lastly, it's disingenuous for a large corporation that may be a name brand to show up with a flip chart and it appears like what it is, which is pandering, as opposed to being sincere and making a big effort to make a good presentation. And so it actually can boomerang and in a way that doesn't seem what you would be expecting. If the independent individual, whether it's typically a plaintiff, shows up with a flip chart or no visuals, they're not going to win because of that. And likewise, no one's going to think that IBM is a big, fat, rich company or any other corporation that's known just because they put on a good visual presentation.
And one thing I'll say is that the jurors already know that the defendant is a big, rich company. Simply having a good presentation is not going to make that fact any more emphasized.
Exactly.
So the next question is, how is this information to be used in marketing to attorneys? And one thing that I'll say is that I think a lot of attorneys don't think about it. When I was practicing, as I expressed my surprise and my dismay at my partner telling me that the science didn't mean S, I think a lot of attorneys aren't thinking about it. Now, the best ones, the litigators that you read about in the news, they know this stuff, and I'm validating what they already know during this presentation. but if you get somebody outside their comfort zone just a little bit and thinking about what they really need to think about to win a trial, they will appreciate it, and that's good marketing, I think. The next question is, how important would it be for the paralegal in the law office to be knowledgeable about how to tell a story? Let's see. They sometimes put the case information together. Well, as a paralegal, I mean, it always helps to know how you win a trial, right? Because number one, litigators are looking to paralegals to make sure their case is well organized, that's kept on schedule, that things are where they need them to be, and that generally things are going smoothly and working well. So if you know this and you can help guide your attorney, maybe if you see things kind of squirming towards the edge of the rails, you can help them stay on track. Or when you see something that would make a good story, you say, hey, Joe, that's a great story. If I was a juror, I would love to know that and hear about it. So, you're always trying to win. You're always trying to help your litigation team, of which you're an important part. So that's why, I would say. The next question is...
actually, I'd like to add to that.
Okay, great.
And I agree with that. I think it's often the paralegals that understand better than some of the litigators that what's happening is not telling a very good story. It's usually the opposite that I see. And so I would say if you're a paralegal and what you're hearing doesn't make sense as an ordinary smart person, then that's something worth, discreetly mentioning, saying, I don't get why we're doing that. That doesn't seem to make sense, or whatever the recommendation may be. I would say, however, that it really has to be the lead of the team that has to determine the story, and it has to trickle down from him or her to the rest of the team. A lot of times, unfortunately, I have seen people who are not the lead on the team have various theories or various levels of control, whether it's witnesses or graphics production, and it ends up not being used and useful because the lead doesn't agree with that version of the story.
Okay, so here is the last question we have time to take today, because we're already way, way over, and I apologize for being so over, and thank everybody who's stuck with us this long. But the last question is, what part does the likability of the storyteller play, and how do you increase that likability? And I know Laurie has a great answer for this, but I'll tell you this much. It makes a great deal of difference. For the same reasons that being popular or winning an election depend on your likability, right? Because a lot of us vote for president because of who we like better, not necessarily because of his or her policies. And you need to present yourself as a likable person to your jury audience. I'll let Laurie get into the how and why of it.
Sure, and the short version is actually likability is 50%, one half of credibility. You don't believe people that you don't want to believe, and ask anyone who's divorced and talking about an ex, that even if their ex is telling the truth, they may not want to hear it and believe it. So we know that, in fact, the likability of the presenter is extremely important, and there are a whole host of criteria that can add or detract from likability. I'll give you a quick short list now, and if you want more, I will tell you later. But the short list is sameness, likeness, using the same language, common ground, being understandable, eye contact, appropriate use of humor, and some other things like that are things that add to it.
And I'll add this: wear a blue tie as much as possible, because it helps. All right.
Even the women?
Yeah, even the women wear a blue tie. So this is the end of our story and of our webinar. Thank you, everybody, for your attention. We very much appreciate your presence online. And we're always available and eager to discuss how to make lawyers more persuasive, so contact us if you ever have a question down the road. And as I said, you're all going to get a notice as to how to get a copy of this webinar after it's over. So again, thank you all very, very much, and have a great day.